this China webinar, which is being staged by the IDR Group. My name is Anthony Connolly. I'm a barrister in practice in London, specializing in international dispute resolution. And I'm pleased to welcome you to this webinar on behalf of the IDR Group. Let me tell you a little about the group. The group was launched at a reception in the Houses of Parliament in April 2008. The group is based in London at the International Dispute Resolution Centre in Fleet Street, close to the law courts. And as some of you may know, the IDRC will soon move to new offices near St. Paul's Cathedral, and we will be moving with them. The membership of the group is made up of international dispute resolution specialists. The members are arbitrators, lawyers, and other professionals from some 20 countries around the world. And members have sat as judges and arbitrators in the International Court of Justice and the Permanent Court of Arbitration in The Hague, and in the International Tribunal for the Law of the Sea in Hamburg. And members also sit as arbitrators and act as advocates in the world's major commercial centres. The group has recently launched a new website, IDR Group Global, and the purpose of the global website is to act as a platform for our series of webinars. The first webinar in the series was in April. That was an energy webinar with the EDAC in Ankara. The second was an art law webinar in May dealing with restitution claims. The third in June was a joint webinar with the International Centre for Dispute Resolution. That's the international section of the American Arbitration Association. The China webinar, which is our fourth webinar in the series. And our panelists are going to speak on two areas relating to China, arbitration and energy. Dr. Li Hu will speak on issues on the amendment of China arbitration law. Professor Liu Song will deal with judicial assistance and supervision of arbitration in China. Then Jingyu Song, a member of our IDR Group, will speak on the launch of International Commercial Disputes and Prevention and Settlement Organization. And then we'll hear a German perspective from Axel Nielmeyer, the regulation and enforcement of Chinese awards in Germany. I'm going to mention arbitration under the CTAC rules, and in particular the CTAC guidance on virtual arbitration hearings. And then moving on to the energy sector, Dr. Carol Nachley will consider China and the energy transition's impact on local and global markets. And then last but not least, Philip Andrew Speed will deal with law for China's low carbon energy transition. We're going to change the order slightly because Carol has a television appearance later today, and so she will speak a little earlier than planned. The bios of all of our panelists are on the global website. Now, turning now to our first speaker, Dr. Li, who is the Vice Chairman of China Maritime Arbitration Commission. He's a commission member and former Deputy Secretary General of CTAC, and a former board member of the Arbitration Institute of the Stockholm Chamber of Commerce. And he's a member of the ICC Commission on Arbitration at ADR and Vice Chairman of ICC's China Commission on Arbitration and Law. Dr. Li is an arbitrator for the International Centre for Settlement of Investment Disputes, ICSID, designated by the government of the People's Republic of China. And he's a member of various international organizations, such as the Asian International Arbitration Centre and the Cairo Regional Centre for International Commercial Arbitration, and a panel member of regional and national institutions in Hong Kong, Taiwan, the United States, Kazakhstan, Southern Africa, Ukraine, Mongolia, and Thailand. And his topic is issues on the amendment of China arbitration law. Dr. Li, over to you.
Okay, thank you, Tony, for your introduction. And I'm very happy to participate in the webinar in concern with China-related arbitrations. So my topic is some issues related to the revision of Chinese arbitration law. So I want to share my opinions with all of you. Uh, some points in connection with the amendments of Chinese arbitration law. The first is panel of arbitrators. In accordance with current Chinese arbitration law, every Chinese arbitration institution shall have a panel of arbitrators. Generally speaking, the parties shall appoint arbitrator from the panel of the arbitration institutions. I think the panel arbitrators may be only for the reference of the parties. So we need a new provision about the appointment of arbitrators. So the panel arbitrator should be only for reference of the parties. The parties may have the right to appoint their own arbitrators and may appoint from the institutional panel or outside the institutional panel. The issue needs to be addressed in the Chinese arbitration law. The second point is the condition of a valid arbitration agreement. In accordance with the current provision of the Chinese arbitration law, the valid arbitration agreement must contain the condition that the designated arbitration institution must be chosen by the parties in the arbitration agreement. Otherwise, the arbitration agreement is invalid. That means that no ad hoc arbitration in mainland. So the issue needs to be addressed in our arbitration law. So the designated arbitration institution shall not be necessary for the valid arbitration agreement. The law should leave space or open room for ad hoc arbitration in China and set up relevant provisions to regulate ad hoc arbitration in China. The third point is the right to decide the jurisdiction and interim measures. Now, in accordance with Chinese law, the right to decide the jurisdiction and interim measures have been vested with the arbitration institution and the Chinese court. So, in my view, the issue also needs to be addressed in the amendment of Chinese arbitration law. So the right should be vested with the tribunal. The recourse of the word, for example, setting aside or enforcement of the word, in the recourse of the word, one of the parties still have a right to challenge tribunal's jurisdiction. The first point is we must respond to the challenge of epidemic error. The virtual hearing or online arbitration may be provided in Chinese arbitration law, and the law needed to set up the basic rules for requirement of due process in case of virtual hearing or online procedure. The number 5 is, as you know, Shanghai and Beijing governments have issued policies to welcome the foreign institution to set up branch offices in Shanghai and Beijing free trade zone. So we also in practice have the practice of SCC arbitration in China. So therefore, in my mind, we need to formulate the rules for the foreign institutions' administration of arbitration in the mainland and identify the criteria to decide the nationality of the word of such arbitrations administered by foreign institutions in mainland China. This is a very, very important issue which needed to be addressed when we amend our Chinese arbitration law. The last point is that we need to further establish the general rules to increase the transparency of Chinese arbitration procedure and to enhance the credibility of arbitration in China. So we must, vest the power to the tribunal, so that the tribunal can have the sufficient direction to conduct arbitration proceedings. This is another point may be addressed when we amend Chinese arbitration law. So that's my basic opinions I want to share with you. That's my brief presentation. Thank you.
Lee, thank you very much indeed. That's marvelous. And we're now going to move to our next speaker, Professor Liu Song. Professor Liu is a graduate of the Law Department of Peking University, the China Foreign Affairs University, and the Free University of Brussels. And he was a Fulbright scholar at the Law School of Stanford University and a visiting scholar at the Max Planck Institute in Hamburg. Professor Liu was admitted to practice Chinese law in 1989, and he's been a part-time counsel for over 10 years. He served as arbitrator since 1989, and he's been involved in around 500 arbitrations, which must be a pretty marvelous record, under the rules of the major institutions, CTAC, BAC, SCIA, SHIAC in Shanghai, Hong Kong International Arbitration Center, ICC, ICDI, UNCITRAL, and CAS. Professor Liu Song has been an ICA handbook reporter for China since 2009, and his publications include the ICA International Handbook on Commercial Arbitration, and you can see his list of publications on the global website. And Professor Liu Song's topic is judicial assistance and supervision of arbitration in China. And I think, are you in Tokyo, Professor Liu Song, at the Olympics?
I was a member of the ad hoc division of CAS in Tokyo. We will provide our service to the Tokyo Olympic Games. But we already have 6 cases. Talk briefly about what we call the judicial review of arbitration cases in China. What I mean by the judicial review is not like there's judicial review under the Constitution. It's about the court activities assisting or supervising arbitration in China. So normally, if we think about the sequence of arbitral proceedings, the court will play a role starting from the arbitral competence, arbitral jurisdictions, if there is a dispute about the arbitral jurisdiction. And then it comes to the court may assist the court in the composition of the arbitral tribunal. Then the court may assist in interim measures or conservative measures. And then after the award has been rendered, the court may play a role in deciding whether the arbitral award will be set aside or not. On the other hand, the prevailing party in the arbitral award will usually petition for enforcement of the award should the losing party not voluntarily perform its obligation under the award. So that's the natural aspects where a court may intervene in arbitration. But what I say about the judicial review in China about arbitration cases only touch upon the arbitral jurisdiction, recognition enforcement of arbitral awards, and setting aside of the arbitral award, only the 3 issues. So that's the judicial review of arbitration in China. The current Chinese legislation on arbitration is the arbitration law, which came into force in 1995. And then the court has very actively assisting, also supervising arbitrations. And I would like to talk, I would like to introduce to you two maybe unique features of the Chinese judicial practice. Number one, the legal basis for the judicial review of arbitration. Of course, number one would be national legislation. We have the arbitration law, and we also have the civil procedure law and some other legislations. But what is important and perhaps characteristic of Chinese judicial practice is that China is basically a civil law jurisdiction. So we do not follow the common law practice of stare decisis. We do not basically follow the precedents. And what, there is a large caseload in China. The legal lawsuits are large caseload, millions of each year. So instead of researching the relevant cases, the Supreme Court in China has issued what they call judicial interpretations. Judicial interpretation, in essence, is still abstract provisions. It's not case law. It's still abstract provisions, but more detailed than the national legislation. I think the idea underlying that practice is that because we have, let's say, almost maybe 10 million cases each year, including all of them, but let's say only 10% will have the effect of law creating, being difficult cases or new cases. 90% will be cases which have not much significant in creating new rules. But still, you look back in the last 33 decades, it's still a large number of cases. So the Supreme Court, what Supreme Court did is they just summarizing and from those cases and rules and provisions and doctrines, and they put it in the judicial interpretations. So the lower court, instead of looking each cases, researching each cases, they just look at the Supreme Court judicial interpretation, which is in more detail and more practicable for the judges in lower court to follow. So this is one, and the judicial interpretation, although theoretically not binding, only binding the lower courts, but the attorneys, the counsels, law professors, in-house counsels, everyone study them. It's very important. So the second feature I would like to introduce is directly related to the judicial review practice, judicial review of arbitration practice. Normally in the legal, I think in legal practice of most of the countries, the higher court cannot intervene to the lower court's activities unless the lower court has rendered its decision. and then there might be appeal or something. However, in China, in the field of judicial review of arbitration, the Supreme Court has created a system which is called report for approval regime, which means, let me give you an example. If foreign related, what we call an international case, arbitration case, has been entertained by the CTAC, where Dr. Li Hu was a leader there, but the respondent challenged the jurisdiction, arbitral jurisdiction, and initiate legal action in court. The court competent to accept this kind of petition will be what we call the intermediate court, not the trial court, the intermediate court. The intermediate court, after hearing the parties, if they decide that the CTAC has no jurisdiction, the arbitral tribunal composed under CTAC rules is not competent, that intermediate court cannot render its decision. They have to report to the next higher court, which is called Beijing, the High Court in Beijing. So they have to report to the higher court. And the High Court, if they agree with the intermediate court's decision, which is a negative decision, means CTAC has no jurisdiction, they still cannot render the decision. They still cannot notify the parties. They have to report further to the Supreme Court. Only after the Supreme Court gave its opinion can the intermediate court render its ruling and notify the parties. The Supreme Court may, the Supreme Court opinion may be CTAC has jurisdiction or CTAC does not have jurisdiction. But it's the Supreme Court who make the final decision. This is for international cases administered by CTAC or any other Chinese arbitral institutions. And now that system has also been applicable to the domestic, purely Chinese domestic cases. However, if it's a domestic cases, the final ultimate decision maker is not the Supreme Court, it's the High Court. High Court, which means the intermediate court, the next to the intermediate court. So, but this practice, I mean, the report for approval regime, I think in the view of the Supreme Court, will ensure the uniform practice of the judicial review or judicial assistance and supervision of arbitration in China. Should you have any questions, would be happy to answer later. Thank you.
That's Mark. Thank you so much, because that was quite fascinating and very, very interesting to hear of the system there. Now, as I mentioned earlier, we're going to take our speakers a little out of order because Dr. Carol Nachley has a television presentation coming up. Now, Dr. Nachley is an international authority on global energy issues, in particular in the fields of hydrocarbons, finance, market development, policy, government, governance, regulation, fiscal regime, and contractual arrangements. And she has a unique breadth of experience spanning different stakeholders in the oil and gas industry all around the world. Dr. Nachley has worked with oil and gas companies, Eni and Statoil at the executive level, governments and policymakers, including special parliamentary advisor in the United Kingdom, international organizations, academic institutions, and specialized think tanks on a global scale. She's active on the governing body of the Board of the Natural Resources Governance Institute, and she's a member of its Audit and Finance Committee. She's on advisory boards of IKAR Industries and the Payne Institute at the Colorado School of Mines. And she's a program advisor in the Washington-based International Tax and Investment Center, and she's lead energy expert with the Geopolitical Intelligence Services. She's also involved in the OECD Policy Dialogue on Natural Resource-Based Development, and she has contributed to the development of the organization's principles for durable extractive contracts. Carol's publications include publications relating to China, and they are listed on our global website. Carol is going to speak on China and the energy transition impact on local and global energy markets. Carol, over to you.
Much, Anthony, and I have to start by apologizing for distorting a little bit the order, especially in terms of the topics, but hopefully it will all make sense at the end of the webinar. So I hope you'll be patient with me. I have lots of slides to share with you, but I will stick to the time allocated to me. I'm an economist, so I refer to data and I love colorful graphs. But really the main message I would like to convey to you today is the impact of what's going on in China in terms of policies related to energy, targets, carbon emissions, and what does it mean for regional and global developments? Because it's one thing to talk only about greening our energy mix, another thing to talk about the less covered repercussions, including on geopolitical developments, investment climate, really a whole chain reaction that is not capturing fair attention, but hopefully it will become more of a topic in the coming months and years. But just to start, for those of you who are not familiar with the situation in China and elsewhere, if you look at where the top 10 energy consumers in the world, where they get their energy from, their primary energy from, you can see that actually China stands out pretty well in a sense that it is the least diversified energy consumer in terms of where it gets its energy from, with coal being the dominant. It is then followed by India, but there is a huge difference between the economic growth of China and India, and China is the second largest economy in the world after the USA. And it's not just the energy mix. Actually, more interesting for me, from an energy transition perspective, is the electricity mix. Where does China gets its electricity from in terms of fuels? And here too, China really stands out in, again, being maybe not less diversified than elsewhere, because if you look at the Middle East as a region, even if you look at individual countries in the Middle East, you can see that there too you have much less diversification than China. But in China, you can see this massive dominance of coal. So when you think about the energy transition in China, you would expect to see this gray bar here being squeezed, not only from the side where you have the green energy sources, including nuclear energy, but most importantly, wind and solar and hydrocarbon and hydropower to a certain extent, but also you would expect to see more of this orange bar, which is natural gas, squeezing more coal, because in electricity, every fuel competes with the other. And really, for me, I think the energy transition, to make a huge difference, it will be all about the future of coal and the future of energy in China. But there's this graph here on the carbon emissions in the world, by country and by region, and the world is in the dark line here. You can see that, interestingly, how China, compared to other major economies such as the US or other major economic blocs such as the EU, has gone against the trend. Even in 2020, when global emissions fell, the Chinese emissions maintained their upward trend. But what did the EU and the US do to kind of decreasing their emissions. It's not just because of COVID-19. This has been an ongoing trend for a while, both in the US and the EU. And there has been an important player, that is natural gas. So that's why I'm very interested in seeing what happens with natural gas policies in China. But here, a small caveat. When we think about the energy mix of other countries or other regions, such as the EU, which is the most aggressive region in the world when it comes to climate policies. So they are pushing pretty hard with climate policies, combining both policies and market-based mechanisms such as carbon pricing and all sorts of legislative measures. It's not an even story. So look how Poland stands out. So you do have the EU, pretty colorful, but when you compare Poland and China, you can see that actually China's energy mix for electricity is more diversified than some of the European countries. So here we have to be careful about, just looking at China in terms of the diversification of its energy, so that even in the most diversified regions, you do have some outliers because they do have other priorities which are actually aligned with those that you find in China. That will be in my conclusion shortly. But here I would like to highlight the interesting aspect when I look at China compared to, for example, the EU and the US, and you can find the same in other economies. So if you look at the climate targets of the EU or the US, you can see how they refer to some absolute reductions in carbon emissions or greenhouse gases compared to a certain base year to be achieved by a certain year. So here the EU, for example, talks about cutting greenhouse gas emissions by more than 55% by 2030. The same thing in the US, the Biden's administration, 50% greenhouse gas emissions reductions by 2030 relative to 2005. And they have done a great job in reducing carbon emissions, in reducing greenhouse gas emissions. But to achieve these targets, they require tripling, if not quadrupling, of their efforts. So keep that in mind in terms of what that means to global energy markets. But look at China. You have to read between the lines. What did China say? China announced ambitious targets, but they talked about reducing carbon intensity, not an absolute value of carbon emissions or greenhouse gases. And that, in my opinion, I find that rather clever because it gives China more flexibility than other countries, because you have here carbon emissions depending to a certain extent, if not to a large extent, on what happens to economic growth, which in turn impacts energy demand and fossil fuel demands in particular. So in this respect, even if Chinese, for example, carbon emissions don't decline, but it is economic growth that declines, then the carbon intensity of the country is going to look better. So if you want, this is kind of makeover or repackaging the target that is still ambitious, but is not as tough as you find in other countries. Whatever, the degree of toughness, the key to all these measures, and that's what the experience from the EU and the US showed us, is to have that first step, that is a transition from coal to gas. Of course, it would be ideal from a climate perspective to switch from coal to renewable energy, but you have the issue of intermittency, which is still there with renewable energy. The infrastructure issue with gas, it's kind of gives you like kind of a stepping stone towards more aggressive policies. And actually, if you look at the numbers, you can see that what you can achieve, for example, here I show you the case of the EU, what you can achieve in terms of greenhouse gas emissions and CO2 emissions from simply transitioning from coal to gas is much shorter and then, for example, transitioning from coal to renewable energy. So it's almost double the time it takes to achieve the same reductions in carbon emissions. So that should be a more straightforward step. However, in China, the outlook for natural gas in favor of coal is far from being certain. Why am I saying this? There is a combination of technical and economic challenges. The technical side, primarily, I mean, you do have under existing conditions, the maximum potential to switch from coal to gas in electricity is around 9% of current coal generation level. That is far from being enough to achieve the more desirable target climate targets. But also there's the issue of carbon price. I know that China is kind of following the footsteps of the EU with their carbon trading scheme, but the prices are still very low to encourage substitution. But there's also a very important dimension, and we saw some of that happening last year and more so earlier this year, and that will lead me to an important dimension in my discussion. That is, the more you switch to gas, and especially like a massive economy such as China, where gas makes a small share of the primary and electricity mix, that is going to exercise an upward pressure on prices. And that by itself makes gas less competitive to coal. So bearing that in mind, in addition to low carbon prices, this incentives to switch from coal to gas is not pretty strong and robust as, for example, what you find elsewhere, such as, for example, in the US, where gas is more competitive than coal because of plentiful supplies, and in the EU because of the policy and legislation push in addition to carbon prices. And then at the end, we shouldn't forget that the Chinese government, right from as far as I remember from the beginning, they continues to find the right balance between energy security, economic development, and the environment. So that will continue to shape China's energy policy. That said, even a small change in Chinese gas demand, so even if they are not close enough to achieving their climate targets, will have massive repercussions on gas markets regionally and globally. And here I want to refer to what happened with LNG markets. At the moment, Japan is the largest LNG importer in the world, but soon China is expected to overtake Japan in that respect. And when there was a dispute between Australia and China, we saw an uptick in the demand for LNG in China because they reduced their imports of coal from Australia. And that alone contributed to a massive increase in LNG prices, particularly in Asia, with repercussions elsewhere. So a small change. So if you're interested in global dynamics, then we have to keep our eyes on China, what's going on there, because that will have that affects directly or indirectly energy markets elsewhere. But look at this, and on this I want to conclude with one more slide, just to end with a note on another dimension, the geopolitical dimension. China and the US, there seems to be some kind of competition between these two largest energy consumers and largest economies in the world in terms of especially renewable green energy race. So you can see there's always like the top 10 spots, or sorry, 5 spots or 2 spots. You find China, US, China, US, US, China, China, US for other sources, hydro, and the same of course for CO2 because of coal. Now that for me has important geopolitical implications, partly because if you look at historical developments, any kind of transition, energy transition, it's not the first time we have an energy transition today. It's a type of energy transition that we have today. But if you look in the past at the change into our energy mix, so whenever, for example, one fuel becomes dominant, with it comes also changes to the geopolitical makeup in the world and the influence of power, the hegemony, the global hegemony, with the countries that have access to that resources. So the British Empire, the Industrial Revolution, driven by coal. The US foreign policies has for decades been influenced by oil. So that we should prepare us to some interesting dynamics in the coming years in terms of political implications. But there is also an economic and social implications in addition to the environmental discussions that dominates climate change discussions today. I mean, look at these simple graphs. You have here, I took it from the World Bank. The World Bank has been publishing regular reports on the impact of the energy transition on the demand of certain metals and minerals that are used to produce, for example, solar panels and wind turbines. And to achieve 2 degrees limit of global warming, not even 1.5 degrees that the world is aiming for today, you would expect to see, for example, demand for lithium increasing by almost 1,000%, cobalt by nearly 600%. You know, these are massive numbers, and they have implications on prices. They will raise concern about security of supply. You know, for decades, we were concerned about security of supplies of oil coming from the Middle East. But where does China fit in this picture? I mean, I found this pretty staggering, that China is the world's largest producer of 32 different commodities, including some that are pretty crucial and play an important role in the energy transition. So while we might think the energy transition may be, you know, adding some kind of burden on China, actually it may carry more opportunities for the Chinese authorities in terms of their broader agenda, and, you know, in addition to their impact on markets, particularly gas markets. Thank you very much for listening. Once again, sorry for chipping into the discussion on arbitration, but I hope this makes sense to you now.
Oh, Carol, that was marvelous, and thank you for staying with us, because I know that you've got a very busy schedule for the rest of the day. So many thanks indeed for your fascinating address to the webinar. We're now going to move on to Xingyu Song. He is a partner in the Global Law Office in Beijing, and I'm delighted to say that he is a long-standing member of the IDR Group. As an advocate, he has represented clients in arbitration proceedings before international arbitration institutions, including CTAC, the Arbitration Institute of the Stockholm Chamber of Commerce, the ICC, the American Arbitration Association, Hong Kong International Arbitration Center, the Singapore International Arbitration Center, and the Japan Commercial Arbitration Association. And he's acted in more than 200 cases. As arbitrator, he has acted in international arbitrations proceedings under CTAC, the ICC, the SCC, and in ad hoc arbitration proceedings. And again, he's acted in more than 200 cases. He's represented clients in court proceedings before all levels of the PRC courts, ranging from district courts to the Supreme People's Court. And he's acted as an expert witness on Chinese arbitration proceedings here in London before the High Court of Justice, and in relation to the Arbitration Institute of the Stockholm Chamber of Commerce. His areas of law on which he advises and his current roles in institutions such as the ICC are set out in his bio, which is on our global website. And Xingyu Song's topic is the launch of the International Commercial Disputes and Prevention and Settlement Organizations. Xingyu Song, over to you.
For inviting me to participate in this webinar in China, and also for the introduction. Today, I would like to share with you information about the launch of the International Commercial Disputes Prevention and Settlement Organization, and new developments of investor-state arbitrations involving China. The launch of the International Commercial Dispute Prevention and Settlement Organization. The organization was formally officially launched on 15th of October 2020. After more than 2 years preparation, it recently moved into its new offices in the city of Beijing, and is now busy with the preparation of its rules, various rules, including rules for mediation, rules for commercial arbitration, and also rules for investment arbitrations. The idea for the launch of the organization was inspired by the success of the AIIB, the Asia Infrastructure Investment Banks. The organization is intended to provide diversified dispute resolution mechanisms and the services for international commerce, including state investor disputes, with the participation of international business and professional organizations, Unlike other existing institutions in China, the organization is open for participation by business and professional organizations from abroad, worldwide. This idea has been well received by the international community, and so far, the organization's membership consists of 50 organizations from more than 20 countries, covering Asia, Europe, Africa, and South America, including such as the China Chamber of International Commerce, the EU-China Friendship Association, the 48 Group Club of the UK, the M4A, the Italian Chinese Chamber of Commerce, the Belgian Chinese Chamber of Commerce, the Russian Federal Chamber of Lawyers, the Law Society of Singapore, the Bar Association of India, the Arbitration Federation of South Africa, the Asian Institutes of Alternative Dispute Resolution, the Union of Myanmar, Federation of Chambers of Commerce and Industry, and the Mexico Business Council of Foreign Trade, etc. According to the charter of the organization, the General Assembly is the supreme authority of the organization, and its governing body is its council, which currently consists of an honorary chairman, a chairman and a vice chairman. The incumbent chairman is Mr. Yu Jianlong. He is also Secretary General of the China Chamber of International Commerce. And the vice chairman is Mr. Derek Vaughan, who is the chairman of the EU-China Friendship Association. And the current honorary chair is Professor Zhang Yuejiao, who is former president of the WHO, the polite body. The organization has now set up its secretariat and is in the process of drafting its various rules, including rules for mediation, rules for commercial arbitration, and investment arbitrations. I have participated in the discussions of the draft arbitration rules, and it has been suggested that the ancestral arbitration rules may be followed to some extent. The draft rules will be published for consultation in the following month in the organization's official website, which is www.icdpaso.org, the initials of the organization. One of the objectives of the organization is to provide business dispute resolution for investment disputes. That means investor-state disputes. This is become a hot. This becomes a hot topic in recent years in China as well as in other places worldwide. A few Chinese arbitration institutions published special rules for investment arbitration in recent years. This includes CTAC and also the Beijing Arbitration Commission. This is in part a response to the increasing number of arbitrations brought by investors against China. In 2020, a total of 3 investment arbitrations were filed by foreign investors against the government of China on the BITs concluded between China and foreign states. In June, a Japanese company filed arbitration against China at the exit under the China-Japan BIT. And in August, a Singapore company filed a request for arbitration. It is an ad hoc arbitration against China under the China-Singapore BIT. And in September, a Singapore national filed another arbitration against China at the exit. The development in 2020 was significant in that before that year, China was only involved in 4 investor arbitrations brought up by investors from Malaysia 2011, South Korea 2014, Germany 2017, and the UK 2019. So far, China has been successful in defending itself in these arbitrations. The first investor arbitration against China brought by Malaysia company in 2011 was settled even before the composition of the arbitral tribunal. The second investor arbitration against China brought by a South Korean company was concluded by way of early dismissal on Article 41.3 of the Exit Convention, with the tribunal finding that the claimant's claims were time-barred due to its failure to commence arbitration within 3 years after it became aware of the alleged violations. The third investor arbitration against China brought by a German company in 2016 is still pending. Our law firm is involved in this arbitration. The hearing has been rescheduled several times due to the COVID pandemic. It is now scheduled for sometime in 2022. The fourth arbitration against China was brought by a UK national in 2019, which is still pending a decision on jurisdiction. I'm afraid I'm running out of time. So Anthony, yeah, it's over to you.
Well, Yusong, thank you very much indeed for that presentation, which was quite fascinating. And we're now going to move on and hear a German view from Axel Niemeyer. Axel studied law and psychology at the University of Hamburg, and from 1981 to 2016, he was a partner in SNB, an independent German law firm with offices in Hamburg, Shanghai, and Ho Chi Minh City. As an attorney, he focused on advice and representation of enterprises in all matters relating to trade and corporate law, and this included advice on domestic and international M&A transactions. The service concentrated on China, and he advised on many investments from and into the People's Republic of China, and he established, supervised, and supported SMB's office in Shanghai. For many years, Axel has been concerned with arbitration proceedings, especially with reference to China. He was a founding member, for example, and managing director of CEAC. That's the Chinese European Arbitration Center based in Hamburg. Axel now exclusively works on arbitration matters. He has extensive practical experience as arbitrator, presiding arbitrator and counsel in various arbitral institutions, including CTAC and SHIAC, the Shanghai International Arbitration Center, SIAC and DIS, the German Arbitration Institute in Cologne, and the Arbitration Court of the Hamburg Chamber of Commerce. Now, his publications include China-related arbitration issues, and he's a regular speaker at China-related conferences. Axel is one of the few German experts on both CTAC and SHIAC arbitration. And Axel's topic is recognition and enforcement of Chinese awards in Germany. Axel, over to you.
Hello to everybody out there. Either it's good afternoon, good evening, or even good morning, wherever you are. It's my pleasure to share with you some practical, very down-to-earth insights into the recognition and enforcement of Chinese arbitral awards in a foreign country, in this case, the foreign country of Germany. All of you are aware that one of the major advantages of arbitration is the enforceability of such an award around the globe, in contrast to civil judgments. However, an arbitral award requires recognition and enforcement by a civil court. Between China and Germany, there is no bilateral agreement on the recognition of civil judgments or on the recognition of arbitral awards. Therefore, the basis for such procedures is the New York Convention of 1958. I trust you are well aware with that. Germany and the People's Republic of China did ratify or accede the UN Convention in the 1950s and the 1980s already. In Germany, recognition and enforcement is governed by the German Code of Civil Procedure. These, the provisions contained in this code have been completely revised as of the 1st of January 1998. And at that time, they adopted completely the UNCITRAL model law. However, the German regulations even liberalized the provision of the UNCITRAL model law. So today, Germany boasts of being an arbitration-friendly nation. Many German arbitral institutions are very active today. The most important, Anthony mentioned that already, is the DIS, the German Arbitration Institute. As for myself, I had the honor of being a co-founder of the Chinese European Arbitration Center, which we set up in Hamburg in the year of 2007. And this arbitration institution focuses exclusively on China-related disputes. Now, how does recognition and enforcement work? First of all, you have to approach a German High Court, the so-called Oberlandesgericht. They are in charge of recognizing foreign arbitral awards. As provided for in the New York Convention, as well as in the German Code of Civil Procedure, you have to submit a certified copy of the foreign arbitral award. However, under German law, and giving regard to the most favored principle in the New York Convention, it is not required to submit a translation of that award unless the other party disputes the genuity of the content of the award submitted. Usually there will be no oral hearing. It will be a proceeding on written documents only. The High Court will decide by an order against which you can appeal to the Federal Civil Court of Germany. Now, one important thing in practice is that the High Court may order, without hearing the respondent before, that claimant may carry out a preliminary enforcement to secure the claims under the award. For example, it could order to seize a bank account of the respondent, or it could order to register a mortgage into the real estate of respondent, which is a very powerful instrument to be used when applying for recognition. Now, having said that, and having shown a little bit of the legal background of recognition proceedings in Germany, I would now like to turn to some practical examples of recognition of Chinese awards. The number of Chinese awards in Germany is pretty small, I would say. There are no specific data available for the specific numbers. So what we have to do is to make a guess. And my guess goes as follows. At CTAC, there were approximately 20 arbitrations per year during the years of 2018 until 2020, which involved a German party. Adding another 10 such arbitrations at other Chinese arbitration institutions, such as the Beijing Arbitration Commission, the Shanghai International Arbitration Center, or the Shenzhen International Arbitration Center, there might be 30 such proceedings or awards per year in total. That is to say, Chinese awards involving a German party. Assuming that 50% of such 30 awards are against the German party, we speak about 15 awards per year. Further assuming that approximately 50% of that will be performed without enforcement, I would estimate the number of recognition proceedings regarding Chinese awards to be around 5 to 8 awards per year in Germany. From my own practice, I'm aware of just one case where recognition of a Chinese award was declined or denied. I would pick out of my practice 3 cases which might be of interest. First one was a case where respondent had disputed in recognition proceedings that the signature under the arbitration agreement was genuine. He claimed that none of its officers or employees had ever made such a signature. Respondent had raised such defense during the arbitration proceedings already. However, the arbitral tribunal had not considered such defense at all. So after taking evidence in that regard, the Hamburg High Court denied recognition because it found that an arbitration agreement did not exist. In the second case, the Chinese claimant filed for a preliminary enforcement into the bank accounts of respondent, together with the application for recognition. And the Düsseldorf High Court granted such request without hearing respondent before. Now, after seizing respondent's bank account, respondent chose to pay. Third example refers to a case where a Chinese claimant filed for a preliminary enforcement into the real estate of respondent. The Hamburg High Court granted such request without hearing respondent before. After charging respondent's real estate with a mortgage, the parties entered into a settlement agreement, and the settlement amount was secured by a mortgage until the full payment of the settlement amount. In these 3 cases, it is worth to note that in the second and the third case, the High Courts did not request an original or certified copy of the award because respondent did not dispute their content. Now, some of the Chinese applications for a recognition of a Chinese award also became published. The decision of the High Courts involved became published. And I would like to share 4 of them with you. In one case of 2004, the Celle High Court denied recognition. Respondent had disputed an arbitration agreement in the arbitral proceedings before CTAC. He argued that the arbitration agreement had not been signed by a duly authorized representative of claimant. So very similar to the first case which I mentioned before. Respondent had not participated in arbitral proceedings. The Celle High Court held that respondent could raise such defense in recognition proceedings. Still, it argued that the arbitral tribunal did not have a competence with regard to the existence of an arbitration agreement. The second published case was decided by the Munich High Court in 2016. It also denied the recognition of an award rendered by SHIAC in this case. It held that claimant had not submitted a duly certified original or a certified copy of the award as required by the UN Convention and by the German Civil Code of Procedure. And they said, respondent did not act in bad faith when disputing the content of the award because it had not participated in the arbitral proceedings. The fourth example would refer to a case by the Frankfurt High Court. It had recognized an award rendered by SHIAC, even though claimant had submitted simple photocopies of the award only, because it held that respondent had not disputed that the copies were true copies of the original award. And last but not least, the Frankfurt High Court in 2014 had recognized an award rendered by the Hong Kong International Arbitration Center. The Frankfurt High Court rejected all of respondents' defense arguments. Most importantly, the argument that wrong arbitration rules have been applied, that there was no oral hearing in the arbitration proceedings, and that the arbitration proceedings violated the German Ordre public. All of these defenses have been rejected and denied by the Frankfurt Court, and the award was declared enforceable. So, to sum up, the recognition and enforcement of Chinese arbitral awards in Germany causes no unique problems. In principle, Chinese arbitral awards do not contain any peculiarities compared to awards from other countries. Thank you for your attention.
Well, I've acted as arbitrator and advocate in China-related arbitrations in London, Beijing and Shanghai under the CTAC rules, and in ad hoc arbitrations subject to the laws of the People's Republic of China. And I have sat as presiding arbitrator on a CTAC tribunal appointed by the chairman of CTAC, sitting with a prominent German arbitrator. The CTAC Secretariat, like other major international arbitral institutions, assists CTAC tribunals in the conduct of the arbitrations. And I'd like to look at, in particular, the effect of COVID-19 on the way in which CTAC and other major international arbitral institutions have reacted to the impact of the pandemic on the conduct of international arbitration. And the reaction has been, to a great extent, to make use of virtual hearings and hybrid hearings, a mixture of in-person and virtual. Now, there are already existing procedures in relation to most international arbitral institutions, which give a wide discretion to tribunals as to how they conduct arbitrations. I mean, for example, Article 35 of the CTAC arbitration rules states that the tribunal is to examine the case in any way it deems appropriate unless otherwise agreed by the parties. Under all circumstances, the arbitral tribunal shall act impartially and fairly and shall afford a reasonable opportunity to both parties present their case. And the arbitral tribunal shall hold oral hearings when examining the case. However, it goes on to say that the arbitral tribunal may examine the case on the basis of documents only if the parties so agree and the arbitral tribunal consents. Now, those provisions are similar to other institutional rules. Say Article 14 of the LCIA rules is one example, which states that the tribunal has a duty to act fairly and impartially as between all parties, giving a reasonable opportunity of putting its case and dealing with that of its opponents. I mean, that's a fairly standard provision in most institutional rules. But moving on to virtual provisions, the onslaught of the pandemic has led institutions to make provisions for tribunals to adapt by making use of virtual hearings. Now, in the case of CTAC, guidelines were issued on the 28th of April last year in an effort to mitigate the effect of the COVID-19 pandemic. And these are entitled Guidelines on Proceedings with Arbitration Activity and during the COVID-19 pandemic. And that's effective from the 1st of May 2020, 1st of May 2020. Article 1.1 of the guidelines refers to Article 35 of the arbitration rules, which I've just referred to. And that states that according to the CTAC arbitration rules, the arbitral tribunal bears the responsibility to proceed with the arbitration efficiently, which is not changed by the pandemic. According to Article 35 of the arbitration rules, the arbitral tribunal enjoys extensive power in actively proceeding with the arbitration and may examine the case in any way it deems appropriate. While taking such measures, the arbitral tribunal shall act impartially and fairly and afford a reasonable opportunity for the parties to give their cases. And then looking at Article 2.6 of those guidelines, which deals with oral hearings, Article 2.6 states that during the pandemic, for cases to be examined with oral hearings, the arbitral tribunal is advised to first consider the possibility of holding virtual hearings. And then it goes on to say that when deciding whether to hold a virtual hearing, the arbitral tribunal shall take into comprehensive consideration a variety of factors, such as the parties' opinions, the complexity of the case, the volume of the evidence, any witnesses to be present, and the justification of the parties' reasons against holding a virtual hearing, and the convenience and equality of the participants to access virtual arbitration hearings. Now, other institutions have updated rules dealing with virtual hearings. The LCIA, for example, in its revised arbitration rules, which took effect from the 1st of October last year, that contains a provision dealing with the use of technology and the conduct of hearings virtually, and that's set out in Article 19.2 of the new LCI rules, which says that a hearing may take place in person or virtually by conference call, video conference, or using other communication technology with participants in one or more geographical places. So it's reference to the possibility of hybrid hearings. The ICC has revised its arbitration rules in force from the 1st of January this year, and Article 26 of those rules deals with virtual hearings. The ICC has also published, like the CTAC has published, a guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. Another organization which has gone along this road is the AAA, the American Arbitration Association's International Center for Dispute Resolution, has produced a model order and procedures for virtual hearings via video conference. And the document is a template which arbitrators and the parties can modify to fit the specific needs of their specific case. So what's the future going to look like? Will international arbitration adopt virtual proceedings? The conduct of international arbitration is likely to be very different following COVID-19. My view is that the use of virtual hearings of one kind or another is bound to continue. Leaving aside documents-only arbitrations, there are already in place various procedures to assist virtual hearings. The major international arbitral bodies such as CTAC give a wide discretion to arbitrators as to how an arbitration is to be conducted. Article 35 of the CTAC rules is an example, and the ICC and LCIA rules specifically authorize video conferencing. So the arbitral procedures are already in place for the conduct of virtual hearings. Will the virtual hearing take over? I don't think it will do completely. It's probably inevitable that more use will be made of remote processes. I mean, the cost implications are pretty obvious, particularly given that parties in international arbitrations tend to be based in different parts of the world and operate in different time zones. And if nothing else, there will all be cases where one party in an international arbitration wants its stay in court. But time will tell what the picture of international arbitrations will look like after the coronavirus epidemic or after its continuation in some form or another. my view is that the hybrid hearing, part face-to-face, part remote, seems to be a likely possibility. Some views there on CTAC and remote arbitration proceedings. We're now going to move on to Philip. We know we've taken Carol slightly out of order, so we're moving on to a section now which is going to deal with energy matters. Carol has already delivered her presentation, and Philip is now going to follow. Philip is a Senior Principal Fellow at the Energy Studies Institute of the National University of Singapore. He has 40 years experience in the field of energy resources, starting his career as a mineral and oil exploration geologist before he moved into the field of energy resource governance. Until 2010, Philip was Professor of Energy Policy at the University of Dundee, and he was Director of the Centre of Energy, Petroleum, Mineral Law and Policy. Philip's current research focuses on the low-carbon energy transition in China and Southeast Asia, and on the governance of nuclear energy. And I'm pleased to say that Philip has been a member of the IDR Group for many years. Philip's latest book, China as a Global Clean Energy Champion, Lifting the Veil, appeared early in 2019. Philip's topic is Law for China's Low Carbon Energy Transition. Philip, over to you.
As you've heard, I'm not a lawyer, but I'm interested in what might be the role of law and litigation in China's low carbon energy transition. Now, China has many laws directly and indirectly related to energy, including mineral resources law, electrical power laws, coal laws, environmental laws, etc., etc. But the most relevant law is really the renewable energy law, amended in 2009, that reinforced the obligation on grid companies to disconnect and dispatch renewable energy, and the law allowed for feed-in tariffs. Now, interestingly, there is still no energy law. I was at a meeting in the Diaoyutai guest house in 2007 about the draft energy law. It doesn't exist anymore yet, but it's on the agenda of the National People's Congress. There is yet no climate change law, and that isn't yet on the agenda of the National People's Congress. Now, one of the sources of confusion, at least for outsiders, let alone for insiders, is the different sources of law in China. You have the National People's Congress that promulgates laws, the basic laws and special laws. But otherwise, true regulations can only come from the State Council or from the People's Congresses of provinces, municipalities, and large cities. However, the State Council, commissions, ministries, People's Congresses, and local governments can all issue local rules, decisions, and orders of different types. And this means that China has a proliferation of documents, some harder than others, that prescribe what actors in the field of energy should or should not be doing, either as the producers or the consumers of energy. And so if we go back to the laws, as many of you will know, many Chinese laws are fairly ambiguous. To an outsider, they read more like policy statements, though there will be specific clauses in some laws that have real effect. As I've mentioned on the renewable energy law, the obligation of the grid to connect and dispatch renewable energy, and we're going to come back to that. But as a result of these multiple sources of more or less hard laws and rules and regulations, there's huge inconsistency and conflict. And this goes back to what was said earlier about the Supreme Court having to give interpretations. So you've got conflicts between basic and special laws, like between the electricity law and the renewable energy law, between laws and regulations, and between regulations and rules issued by different levels of government. The judiciary, despite improvements, is still politicized and judgments are inconsistent. But coming to the energy transition, there are very few cases, at least that my colleagues have found, relating to renewable energy. And this is in contrast to the environment, and we're going to come back to that. So in the renewable energy field, mediation is the preferred route if a renewable energy plant doesn't get dispatched, and the National Energy Administration or the National Development and the Reform Commission will usually be the mediator, i.e. the government is the mediator. But another way out for the grid companies is to look at the power purchase agreement, where there is always an exemption relating to grid stability and safety. And that exemption is always often called up, even if it is not really valid. Now, my final points relate to public interest litigation. And this, in the last 5 or 6 years, has become really important in the environmental field. So the Environmental Protection Law of 2015 allowed registered Chinese NGOs to file public interest claims relating to the environment. The Renewable Energy Law of 2009 amended gave the grid obligations to connect and dispatch renewable energy. In 2016, the Chinese NGO, the Friends of Nature, filed 2 cases against grid companies, respectively in Gansu and Ningxia. And in simple terms, these cases have gone nowhere. They've gone up and down to different levels of court. After 5 years, at least I'm informed that they have not been resolved. So environmental protection law, NGOs taking cases against companies not dispatching renewable does not seem to be going anywhere. Now, in 2017, China amended the civil and administrative procedure laws. This allowed procuratoriates, the government prosecutors, to be more active in environmental cases. And they've been filing tens of thousands of environmental cases against government agencies and against companies each year. And that's very good, but it doesn't seem to involve renewable energy and clean energy. It's more conventional pollution cases. And so this is a real problem. And a colleague of mine says, well, one of the problems with the environmental law is it doesn't classify carbon dioxide as a pollutant. So we now come to the National Emissions Trading Scheme, which, as you know, started a couple of weeks ago. It could be very important. What rules govern it? Purely measures introduced by the Ministry of Ecology and the Environment. And these will be administered administratively. These are administrative measures. So again, one asks, is the implementation of this National Emissions Trading Scheme purely up to the Ministry of Ecology and its local offices to make sure it's working? And will there be any scope for NGOs, procuratoriates, or anybody else to take local government agencies or companies involved in the scheme to litigation for not following the rules? And my understanding, well, I mean, it's very early, we're only 2 weeks in, but if we look back at the last few years, there doesn't seem to be much scope for using formal legal processes to enforce good behavior in this new National Emissions Trading Scheme. So if we step back and I'm looking at, what is the role of law and litigation in the low carbon energy transition? The answer is it's been pretty small to date. It is mainly through administrative instruments on officials to do their job, and on inspection tours, as we just had from the Ministry of Environment, going around and looking at what local governments are doing. So I rest my case. The role of law in the low carbon energy transition appears to be small, but we look forward to that maybe improving in the coming years. Thank you very much, Tony.
Well, Philip, thank you so much for that. You've raised some very interesting and fascinating points there. We will be planning. We've had one energy webinar so far in this series. We're planning a second one, and I think there are points raised by all of our speakers today which would be of great interest on a second energy webinar. Well, you've taken us very nicely to our allotted time of 90 minutes. So it just remains for me, on behalf of the IDR Group, to thank all of our panelists for their presentations. And we've had very impressive talks from Dr. Li Hu, from Professor Lu Song, Jingyu Song, and Axel Neilmeyer giving us a German view, and from Dr. Carol Nackley, and lastly from Philip. Our thanks to them all. Thanks also to Dr. Edward Murphy for his support in this series of webinars. Special thanks to our delegates. I mean, the interest in this webinar has been worldwide. We've had delegates registering from Nigeria, Lebanon, Canada, South Africa, Iran, Indonesia, China, Italy, Singapore, Egypt, Germany, Malaysia, Brazil, Saudi Arabia, and the UK. So a very, very widespread of people interested in this. And can I again thank our delegates and say, keep an eye on our global website for future webinars. Thank you for joining us. Goodbye.